Well, I'm back again with my law students from McGeorge, and I'm super excited to talk about the death of amateurism. Is it really over? And I have Lynn Tran, Kristen Root, and Emma
Yes, Emma
Vizaga to explore one of the most significant turning points in the history of college athletics. So, to kick us off, we have Lynn. Lynn, tell us what amateurism is and where it came from.
First off, Professor Baxter, thank you for having me and my teammates Kristen and Emma on your podcast. We're very excited to be here. So, in terms of amateurism, for more than a century, the NCAA has relied on this principle to justify its rules and limitations on athlete compensation. Amateurism in this context means that student athletes are not professionals and therefore cannot be paid for playing their sport. They're supposed to compete for love of the game and not for financial gain. But when we peel back the layers, we see that amateurism wasn't always about fairness or integrity. It was about exclusion. The origins of amateurism trace back to the 19th century Britain, where the elite used the concept of keeping the working class athletes out of prestigious sports like rowing and track. So amateurism often excluded working class athletes who needed to earn a living, while wealthy individuals, typically aristocrats, who had the time and the financial means to compete without pay. So in a way, amateurism became a tool for reinforcing social class divisions rather than a principle rooted in fairness.
Oh, wow, that's really interesting. So how did that idea carry over into American college sports?
Yes, it's very interesting. So the NCAA adopted this British model in the early 1900s, wrapping it in the idea that I had previously mentioned, that college athletes should play for love of the game and not for money. So under this framework, student athletes could receive scholarships and limited cost of living stipends, but they were strictly prohibited from profiting from their name, their image, and their likeness, or from being paid for their athletic performance. But this model increasingly came under scrutiny. As college football and basketball became multi-billion-dollar industries, contradictions in the amateurism framework became impossible to ignore. Universities had massive media right deals, coaches earned multi-million-dollar salaries, yet athletes, many of them from low-income minority backgrounds, were denied any share of the revenue they helped to generate.
That contrast really highlights the imbalance. So was there also legal reasoning behind the NCAA's insistence on the amateur model, Lynn?
Yes, in fact, the NCAA popularized the term student athlete in the 1950s, not just as a cultural ideal, but as a legal shield. By labeling athletes as students first and foremost, the NCAA could argue that they weren't employees and therefore they weren't entitled to wages, workers' compensation, or collective bargaining rights. It was a deliberate move to limit legal liability and financial obligation. Over time, this hypocrisy became harder to justify. These so-called student athletes train year-round, play in front of national audiences, and risk career-ending injuries, yet they couldn't accept a free meal, sign a sponsorship, or post on social media for pay. And so the pressure mounted both publicly and legally to reconsider the fairness and legality of the amateurism model.
Exactly, so that's where we are right now. The legal challenges and the dismantling, really, of amateurism. So this sets the stage perfectly, Lynn. So let's talk about how that pressure started to translate into actual legal challenges. So Kristen, can you walk us through the major cases that started to dismantle amateurism and lead us to where we are today? I do want to say something about Kristen. Kristen was a student athlete and she did play volleyball in college. So her perspective to me is really going to be interesting. So tell us what happened, Kristen.
Absolutely. So there were three major cases currently related to athletes and amateurism. The landmark case is O'Bannon versus NCAA, which was the first case of this kind. So Ed O'Bannon is the former UCLA basketball star from the 1995 national championship team. He filed the lawsuit in 2009, and he was joined by other former college athletes. This case is in a great book he wrote called Court Justice, The Inside Story of My Battle Against the NCAA, which we read in this class and highly recommend that everyone interested in this read. So what happened was that O'Bannon discovered that EA Sports had used a player in a video game that looked like him and played for UCLA, but he was never paid for it. He sued the NCAA over the use of athletes' names, image, and likeness in video games and other media without compensating the athletes. The NCAA had rules that banned student athletes from being paid even after graduation based on the principles of amateurism. So the main issue in this case was, can the NCAA prevent college athletes from being paid for the use of their name, image, and likeness, NIL? And the legal question was, did the NCAA violate antitrust law by preventing athletes from being paid for their NIL? So O'Bannon's legal team argued that this artificially suppressed the value of athletes' NIL rights, which would otherwise be worth money in a free market. This lawsuit was decided in 2014, so it took several years. A federal judge ruled that the NCAA's rules violated antitrust laws by banning payments for NIL. The court allowed limited trust fund payments up to a cost of attendance, but struck down direct compensation beyond that. Colleges could offer athletes more than scholarships, including trust fund payments up to the full cost of attendance. So the key outcomes in O'Bannon are that the NCAA's amateurism model was ruled as not above the law. Schools were allowed to give athletes additional educational aid, and it set precedent for later cases that I'll discuss here shortly, like Alston and House. It helped lead to the current NIL era, which we'll discuss in House. The impact of this case are that it set the foundation for legal recognition of athletes' NIL rights and paved the way for later legislation and lawsuits allowing athletes to profit from endorsements, social media, etc. O'Bannon matters because this case opened the door to challenging the NCAA's control over athlete compensation. It proved that amateurism isn't a legal shield against antitrust scrutiny, and it shifted public and legal attitudes toward recognizing college athletes as economic contributors. So after O'Bannon, the next sort of landmark case we had was NCAA versus Alston in 2021. This was a major U.S. Supreme Court decision that further chipped away at the NCAA's amateurism model, especially regarding limits on education-related benefits for college athletes. The lead plaintiff in this case was Sean Alston, a former West Virginia University football player, and several basketball players joined him. The defendant was the NCAA along with the major athletic conferences. The main issue was, can the NCAA limit educational-related benefits to student athletes, things like laptops, scholarships for grad school, etc., because the NCAA did limit what schools could give athletes beyond scholarships, things like computers, paid internships, graduate school scholarships, and academic awards. So Alston and other athletes argued that these limits unfairly suppress their market value, even for legitimate educational support. The outcome in this case was a unanimous U.S. Supreme Court decision against the NCAA. They ruled the NCAA restrictions on education-related benefits violated antitrust laws. Justice Kavanaugh gave the concurring opinion where he strongly criticized the NCAA's business model, suggesting further restrictions could also be illegal. He said, the NCAA is not above the law. Price-fixing labor is price-fixing labor, whether it's done by the NCAA or any other company. So the key findings in the Alston case were that the NCAA rules violated the Sherman Antitrust Act by restricting benefits that are clearly tied to education. Schools must be allowed to offer athletes reasonable education-related benefits. The outcomes from Alston are that schools can now offer more academic benefits like scholarships for graduate and professional school, study abroad programs, internships, tutoring, laptops, and more. Alston matters because though the ruling was narrow and focused on only education-related benefits, it's at a massive precedent. The court made it clear athletic compensation rules are subject to antitrust laws, and Justice Kavanaugh's opinion suggested the NCAA might not be able to legally justify broader compensation bans either. So the next case that takes us to is the House case, House versus NCAA, which is ongoing as of this year. It was filed in 2020 by former Arizona State University swimmer Grant House, along with other student athletes. And this is a class action antitrust lawsuit. The main issue is, should athletes be paid a share of revenue from broadcasting and video games and be compensated retroactively for past NIL use? The case challenges the NCAA's historical rules that prohibited athletes from earning money for their name, image, and likeness, including from things like broadcast revenues, video games, social media, and endorsements. The plaintiffs are asking for back pay for athletes who were denied NIL compensation before 2021 when the NIL rules changed, and a share of future broadcasting and media revenues. What makes it different from O'Bannon or Alston? While O'Bannon and Alston chipped away at restrictions, House aims at the heart of NCAA revenue. It goes after billions in TV contracts, video game licensing, and sponsorship. It argues that schools should be required to share those revenue with athletes. And as of this year, the NCAA has agreed to a $2.8 billion settlement in this class action lawsuit. The settlement would pay former athletes back pay for prior NIL restrictions between 2016 and 2021, allow schools to pay athletes a share of revenue going
Actually,
forward.
It's through 2024. I'm just going to correct you on that.
Oh, thank
That's
you.
okay.
2024. Additionally, it allows schools to pay athletes a share of revenue going forward, up to $20 million per year per school. Create a new model where athletes are treated more like paid partners than unpaid amateurs. And this is the first time in NCAA history that schools are allowed and expected to directly compensate athletes. So this matters because this truly marks the death of NCAA's amateurism model as we've known it thus far. It could fundamentally reshape the economics of college sports, with schools allocating money for athlete salaries, and it may lead to roster restructuring, cutting other programs, and unionization efforts by athletes. I think we're already starting to see those things. So all three of these cases overall impact NCAA sports because they're dismantling amateurism step by step. Athletes can now profit from their name, image, and likeness, and soon may be directly paid by schools. Schools need to adjust their budgets and business models, likely cutting costs elsewhere or reshaping rosters. And so in short, these cases didn't just weaken amateurism, they dismantled it.
Wow, what a great summary of those three cases, because they are complicated, aren't they?
They're a little difficult when you first read them, yes.
Yes, but now are we more clear, and my audience should be more clear about how all these three cases work together?
I think so.
So you used to be a student athlete. What if this would have been available to you?
I definitely would have tried to cash in, I can tell you that.
Okay, well, that's good. All right, so the next person we're going to talk to is Emma. So Emma, what comes next? How, now that the traditional model of amateurism has been fundamentally altered, what comes next for college athletics? What should we be watching for, Emma?
Well, I think this is a very interesting question. As my two wonderful colleagues discussed, amateurism is a far more complex concept than we had imagined. As Lynn just addressed, it has a long history rooted in class segregation, in which elite and higher class men exclude lower working class men from, joining their circle. And as history moves, there are several significant court cases presented by Kristen. It significantly moved the situation of college athletes by ensuring that some of their fundamental rights, like revenue sharing or some payback compensation, NIL rights. So now the question is whether this is the true end of amateurism for college athletes. And I would dive into this conversation in two aspects. One is, should college athletes be considered as working employees, and the second is some hidden gender equality issue that is embedded in amateurism. Mm-hmm. So the first aspect is whether college athletes should be considered as working employees and receive fair compensation from that. because even after the House versus NCAA settlement right now, college athletes still are not compensated as a standard working employee, and not to say to compare with like a professional athlete salary. And I would like to provide the audience with some statistics, and I hope those statistics can give us some, thought-provoking opportunity. So according to the NCAA, their official rules limit the countable athletically related activity to 20 hours per week for college athletes. But by numerous studies and surveys conducted by both NCAA and other institutions, it suggests the actual time commitment is much, much higher than 20 hours per week. And they say that on average, sometimes it's 40 hours, even more than 40 hours per week during the playing season, especially for the Division I college athletes. And so this time commitment is equivalent to a full-time job, and it frequently forces the college athlete to compensate on their academic achievements. And on top of that, the NCAA in 2010 conducted a survey on nearly 20,000 current athletes at the time from 611 institutions in all three divisions. And it showed that, particularly Division I college athletes on average misses 2 classes per week for their academic year. And so I feel like we can imagine this challenging level that those college athletes are having, kind of like a full-time job thing while attending school regularly, finishing their assignments, maintaining certain GPA for their scholarship and major requirements. And I can imagine it's really challenging to overcome that every single day.
And now what they've added is this NIL stuff. If they have NIL deals, they have to go and perform. Meaning, I gotta go over to the car dealership, or I've gotta go. Keep going. I didn't mean to interrupt you.
Oh, no,
but
no.
it's part of it.
Mm-hmm.
It's. They now have another obligation. They need to be on social media. They need to be. They have other obligations to make money off their name, image, and likeness. But keep going.
Yeah, exactly. So for me, it's also a new thing that I learned how much obligations those college athletes that they have. And at first, even I thought, most of the college athletes, they receive scholarship, they're going to college for free. But after conducting research, actually the majority of college athletes, they do not receive any scholarship.
Right.
And
a lot of schools do not give scholarship.
They don't give scholarship. The only scholarship they can offer for college athletes are usually the Division I or Division II. And only approximately 1% of college athletes receive a full ride scholarship.
That is a very good stat to provide.
And that's typically in Division I. Okay. And on average, this is on their NCAA's website, that they said average scholarship for all sports in Division I is roughly $14,000 a year for men and $15,000 a year for women. And for Division II, that number drops significantly to $5,000 to $6,000 a year. Mm-hmm. And I did the math, and if this is a full-time job, they basically get compensated. This 1% or very few college athletes, they're compensated for their time about $1,200 a month, or we can say $7.8 per hour as a full-time employee. And just for reference, minimum wage in California is $16.5 per hour, and the federal minimum wage is $7.5 per hour. And so we can see this is such a, I would say this is such a challenging situation for them. And at least it's much harder than I imagined from the beginning. And on top of that, NCAA also did a research, and it revealed that college athletes frequently face things like sleep deprivation, and 61% of student athletes report they feel daily fatigue at least 3 or more times a week. And the follow-up survey on that in 2021 also indicated elevated rates of mental exhaustion, anxiety, feeling of depression, nearly 10,000 college athletes at the time. And so I guess I provide those statistics. There's no right or wrong answer, but I feel like my question, kind of like for everyone and also for the audience, is to reflect on, should we right now identify or define college athlete as a working employee, and hence they should receive compensations that is subject under labor law, potentially. But that's a big question. I feel like everyone can think about it.
And there are some cases out there on that.
Yeah.
There's a couple of them that are out there, and I don't know that they've been resolved 100% because of different reasons, but it is very interesting.
Yeah.
So what about Title IX, Emma?
Yeah, so this brings to the second aspect I'm going to talk about, is a gender equality issue in this, amateurism. And the reason I feel this is a really important topic to talk about is, according to NCAA, there are currently more than 520,000 college athletes. And women college athletes are counted 235,000 people. And if you do the math, that's about 44% of all registered NCAA college athletes. That's nearly half percentage. So clearly women are important participants in college sports. And additionally, NCAA did a research based on the research that I mentioned previously, that women college athletes actually tend to face 1.6 to 2 times higher mental distress than men college athletes in college.
Wow.
And on average, more women athletes miss more than 3 classes per week than men's college athlete. And additionally, women college athletes miss more classes than men college athletes in all sport categories except football, because football is a typical all-men sports. So we can see that women college students are a significant part, and they're facing a lot of, I would say, a lot more stress in this environment. So that interestingly brought to our conversation on Title IX, because currently, right after the House versus NCAA settlement, there are 8 women college athletes filing an appeal to the House settlement because they argue that the term of the settlement violated the Title IX. And they did previously on March 17th already filed like an objection to the court, because they are saying that there was a $1.14 billion error in the planning distribution of the settlement payout.
For previous deals, or for
like when the final deal was not done yet,
Okay.
they already filed like an objection to that settlement proposal.
Okay.
But that didn't succeed. So right now they're filing a notice of appeal to the final settlement. And their argument is basically saying that the current settlement distribution is based on a market analysis provided by expert Dr. Dan Rasher. And under his analysis, that settlement distribution is will go out about 75% to football team, 15% to men's basketball team, and women's basketball team have about 5%, and the rest of the 5% to all the other sports that are in colleges. And so this group of challengers, they call themselves Title IX objectors, and they argue that under Title IX, women athletes should receive up to 47% of the payout. That's a huge difference.
Yes.
And they stand on the ground that, when women are such they account for 44% of all college athletes, and this calculation distribution system certainly favors men over women, because men's sports, the most popular ones are football, basketball, but women's most had the highest participation are like field and track, and soccer, softball, volleyball, and it's very interesting to see there are like increasing other women's sports other than gymnastic or tennis. There is also like wrestling or triathlon. Those kind of things are increasing a lot. So certainly it raised a lot of criticisms on this action. And first of all, the House plaintiff's attorney, Steve Berman, he is very displeased with this action because this appeal would pause the payment for the payback damages to the athlete beneficiaries for potentially several months or years. And so he argued that this is an antitrust case for competition. It's not about Title IX. And if they think this is a Title IX, they should wait and then later bring a completely different lawsuit, not filing an appeal. And also NCAA and the conferences, they held the position that there's no need to consider Title IX because it does not apply to them. They're not a governmental entity. But those objectors or appellants, they point out that ultimately the school institutions, rather than the conferences, are the ones will disperse the payments, and the school institutions, they are subject under Title IX. So that's their argument. So it would be interesting to see how this appeal would evolve in the future, and bring in potential Title IX issue, and it certainly will generate a lot of conversations. We don't have the right answer. We don't know what's going to happen.
What's interesting is during the settlement hearings, which I listened to, Judge Wilkins, and she did say this isn't a Title IX case. I mean, she talks about it several times. So it will be interesting to see how this evolved. I think everybody did anticipate that there would be a Title IX case.
Yeah.
I don't think that this is like a surprise.
Yeah.
Okay, to be honest with you. But is there anything else any of you want to add based on what you've said so far?
Well, I just want to wrap it up because I believe as a society, as Kristen said, we dismantled amateurism step by step through all those significant court cases going on. And I believe we are moving forward, we're progressing in the right direction. And at the same time, there is still considerable work that needs to be done in the future. So I feel like I will leave the question to all of us who are sitting here and also the audience who are listening. Like, do you think amateurism is dead? And there are no right or wrong answer, but I hope like our information provided can generate some thought-provoking conversation among everyone.
Yeah, well, this was amazing, and thanks to all of you for helping unpack such a complex and evolving issue. From its historical roots to its legal unraveling to the uncertain future, the story of amateurism in college sports is far from over. This has been the death of amateurism. Is it really over or not? Thank you so much for listening, and if anybody out there who's listening feels like, boy, this was a good explanation, which I think it was, and dealt with many issues going on with the House settlement and just antitrust laws in general, please share it with everyone who you think would be interested in this topic. And please subscribe to Born to be a Sports Agent. And if you have any questions for Jill, just email me at jillbaxter@me.com. Thank you so much, Emma, Kristen, and Lynn, for sharing all of your valuable information.